So again, thanks for joining everybody this afternoon. Use the Q&A box and we're going to work through our questions. And I'll start answering the questions that we've got here. So thank you everybody who has gone ahead and put questions in the Q&A feature. And then we'll work through that and those questions as we go. There's David. Well, good afternoon, David. You joined just in time as I'm getting ready to jump in with our first question. So any opening thoughts of wisdom before we start answering the questions that everybody's got for us?
Boy, have we ever had a more busy, fractious, difficult time in all of our careers. At this point, I'm just glad to be here. I trust you can hear me okay?
Yeah, no, you sound great. You look great. We got you loud and clear, and we'll jump right in. And I mean, I know right now, I mean, everybody's getting it from every side. You know, to be a school board member or a school administrator right now, there is no winning. There is no pleasing everybody. And so we've all got to just, I think, slow down, take a deep breath, get all the information you can, and then make decisions based on that. I mean, I think that's where we are right now.
I mean, at this point, I'm starting to wonder if there's any pleasing anybody, let alone pleasing everybody. Is there any pleasing anybody at this point?
I think that is a fair assertion. But guess what? It's Friday. Now, absent any new guidance coming out on Fridays, as sometimes you know, we do tend to get, but nevertheless, we'll see if we can
guess what? It's nevertheless
do what we're gonna do. All right, well, David, I'm going to start with first question that I see here is one that I think is a pretty straightforward one. And that is remote learning required for us to offer students under quarantine? And the answer right now from ISB is yes. Based on their most recent FAQ of August 31st, based on the ISB resolution that was passed this week, the answer is yes. We are required to provide remote learning for students under quarantine, and that as part of that, you know, that meets some of those standards for remote learning last year. And I think that that's an important question because I think that was a change. I know that ISB has maybe not viewed it that way directly, but I certainly think based on the guidance that we had prior to that most recent FAQ, I think that is a change. I think before that it was recommended for students who were not vaccinated or unable to be vaccinated who are under quarantine. And now I think that plainly the ISB guidance and the ISB resolution indicates that we must provide remote learning in that situation.
Yeah, I don't think at this point there's any question. And frankly, you know, I admit my own bias on this subject, that to my mind, why wouldn't we be providing every educational opportunity that we could for every kid that we have the option to provide a remote option for? To my mind, the bigger problem with the guidance before was it seemed to really limit the number of kids that we could provide remote learning opportunities for. I think we've seen some of the cases that we've seen to date that have gone kind of sideways in some places, meaning we didn't necessarily predict what the result would be, and it came out a little differently than we might have predicted. One of the things that I've been at least a little bit concerned about is that in some of those cases, some of those decisions seem to turn on the degree to which the school provided an education to the children and whether they met that obligation. And I think that to the extent that we can continue to impress upon any court that might hear the case that we've done everything we can to give the kids the best educational opportunity to which they're entitled, I think we're going to have better chances of success, and frankly, just a better moral argument for whatever it is that you may be choosing to do. I also want to acknowledge the difficulty of that, because I also understand that to the extent that you make those decisions, you're going to have you're going to have some bargaining implications.
Yes.
This may not be very
Yeah.
easy to deal with directly, and I think that we need to be prepared to deal with our union on those.
Yeah, that was gonna be my
matters.
point. I think one of the main reasons, primary reasons why I think there was some reluctance to go all in on remote learning, even before the change from ISB here, was the bargaining implications and the stance of the union on that issue. So I think that's a fair point. I got a couple questions here that came in on an email that relate to this kind of remote learning issue first, before we get into all of the testing mandate questions that are there. You know, do you have any recommendations related to homebound instruction given the increase in cases? You know, we're working with our health department to try and figure out how we're going to provide services, especially to provide services in the home. And I think that, you know, I think we need to recognize a couple things when it comes to homebound, which is one, homebound services can be provided remotely or virtually under the regulations. But I recognize, and I think this question is really about those students for whom virtual doesn't really work and they really do need some form of in-person homebound. I mean, I think that we need to really think about whether that's safe and how we can layer mitigations in place. So knowing about vaccination status, wearing masks, having testing in place, I think those would be the types of considerations I would have before I'm talking about going into a home to provide a homebound. And especially this fall when the weather's nice, can we provide a homebound on the porch? So we're outdoors, you know, in situations where that's available. But I would start with, can we look at providing that remotely or virtually when we don't think it's safe to do it in person?
Yeah, and again, I think it's just really important that we keep coming back to the collective bargaining implications, because I don't know about you, Brandon, but I've seen a whole bunch of places where we've had to deal with sort of those out of nowhere collective bargaining demands where we feel like we haven't necessarily made any particular changes, but the union says, well, no, wait a minute, but everything's different this year. Okay, so I understand you think you're going back to last year and your lawyer did a really fancy job with his status quo waivers. And so we've got everything waived and we're just going to make these decisions now to go back to how it was, but it's not how it was. And while I may have viable arguments about what the practice is, because last year was a weird year and we accepted it out, I don't think it does any good if we have a bunch of employees who refuse to show up. So I think that we need to be working very closely with our union and thinking about the fact that despite the fact that we're under pressure to give good, we're under pressure to provide good services for the students. It's also important that we remember we have people on the ground who've got to provide those services. And before, whatever our view may be on what the risk actually is or isn't, it's important that we preserve our ability to actually get those people there.
Yeah.
I mean, one of the things that's really scared me this year is I've heard more talk of teachers maybe just not doing it than I've ever heard before. Maybe we just won't do it. I've literally gotten that in bargaining meetings, and I think that's a very real risk we're going to have to contend with.
All right. Well, I'm going to go down this list here. A couple questions here regarding the testing mandate. Are booster group, concession stand workers, et cetera, required to show proof since they are around people on school property? I think the answer is they fall within that volunteer if they're going to be in close contact with any other person for more than 15 minutes or more once a week.
Yeah, I think during the period of once a week, as long as it's regular once a week, yes, technically they fit within the mandate.
Next question here, unvaccinated staff member tests positive, completes the isolation, quarantine, comes back, works, tests again, and is still going to test positive for a while and could test positive for several weeks. What do we do? And I think my answer to that is the local health department makes the decision on what we do.
Yeah, I think that's a real point of stern warning at this juncture that we have to make sure that everybody understands that we've gotten from the courts to date, and that is that at the end of the day, we aren't health authorities. We don't make health decisions. And so I think it's really important that we keep reminding ourselves there's a limit to what we have a duty to do, but also a limit to the amount of control and responsibility that we therefore have. We don't have I think ISBE's worked really hard to try to keep everybody safe. And as a function of working very hard to try to keep everybody safe, they put administrators on notice of a lot of apparent responsibilities that you have. And I think a lot of us have the desire to take on a lot of these things for ourselves. And I'm going to caution that, remember, you aren't health authorities and you don't have health authority knowledge. Guys, I'm not going to make any pronouncements during this meeting about what works and what doesn't work. I don't know. But that's exactly it. I don't know. And frankly, you don't want to pay me to hire a bunch of doctors and epidemiologists and physicists to make these determinations. I know some of you have heard me say that before. You don't want to have to make those decisions. So we have to trust the health authorities. And when the health authorities give us answers, we have to do what they tell us to do, to the extent that those answers are answers they're going to defend. Now, if they're directing you to do things, that's going to be a little bit different. We'll talk about that as we go here. But to the extent that the directives are for you, to my mind, that's where we are. If they give you a straight, you're going to do X, that's what we have to do.
I totally agree. Several families are now refusing to wear masks, providing a refusal to give consent notice letter. How is that best handled? Well, I think going back to, the bottom line and things that we've talked about all along, the mask mandate is a mask mandate, and we are tasked with enforcing it. So I think the mask letters, to me, outside of those limited, disability related medical contraindications where we're making 504 or IEP team decisions about that. When it comes to a mask, any other basis for refusal to me is just simply denied. I don't think, we get lots of questions here, coming up as we talk about the testing and vaccine mandate about things like the Healthcare Right of Conscience Act and, other types of concerns that are out there. I just don't think that applies to masks. So at this point, we just continue to enforce the mask mandate.
Yeah, and I think it's important that I've had this conversation with a couple of folks in the last couple of weeks, that I think it's important we really distinguish the difference between a medical device or a medical choice and an article of clothing. To my mind, masks remain. Now, I acknowledge there are cases everywhere. And for the moment, my advice is going to be like this for the moment, because so far the cases have been unanimous on this point. But I acknowledge that it's moving target. I said to a board in an open board meeting, somebody asked me, but does that mean that this can just continue forever and we can be masked for the rest of time? I acknowledge there's a point at which we cross the threshold and it may not be reasonable anymore. It's just that I'm not sure if we're there yet. At this moment, as I talk to you today, I don't believe that we've reached the point where we're likely going to see the mask mandate undermined on a broad scale, maybe in individual cases, on individual facts, but I think on a broad scale, I'm not yet to that point, because at the moment, I still think that the mask effectively is pants. And guys, we mandate pants in schools. We mandate shoes in schools. And so to my mind, I don't want to think about that as a medical device, because I don't know that it is a medical device. I don't know that it's ever been held to be a medical device. And until a court does hold that way, to my mind, what we're really dealing with right now is a dress code issue, and one that really is mandated from the governor, and then an IDPH and ISBE, and over which we don't have any control, and which has frankly been upheld a whole bunch of times, versus vaccines and where there's an actual invasion into the body, as well as the testing where there may be some degree of search involved, which to my mind are very different, because it's hard to argue those don't have some degree of medical procedure involved.
Related question here: to what degree do we challenge medical contraindications that come from chiropractors? And I think ultimately, I don't know that I care who it comes from so much as what it says, because still I'm going to take that through the IEP or 504 process. Is it evidence of a disability? Do we need to make this accommodation based on the disability? That's where we're going to have medical contraindications. Anybody who's going to have a true medical contraindication is going to have either an IEP or 504 plan, right? I mean, and if they don't, then we're going to start a 504 process for them. So the degree to which we do that is based upon the degree to which it indicates that there's really an underlying disability or health condition that would qualify under Section 504. I think that's where we think about that and how we think about that.
Yeah, and I mean, again, I come back with these issues to the fact that there is a doctor giving a note is not the end of the inquiry, it's the beginning of the inquiry.
Yeah.
I recognize that there are different fights in different places and different levels of fight in you in different places. And I think you've got to make those decisions individually based on the individual circumstances. But I view a doctor's note very differently if the doctor says, I'm going to make up ridiculous facts. The chiropractor says she came in and said she's asthmatic. I didn't examine, but I write this note and it says nothing else. I view that completely differently than a neurologist who sends a 14-page letter explaining the nature of somebody's anxiety and the different contraindications and the reason that we need to examine certain accommodations and the nature of those accommodations, the way they need to work. The doctor's note is the beginning of the inquiry. It's not the end of the inquiry. That doesn't mean we're setting them for a medical examination. It means we're going to start asking some questions, and this provides us the basis to ask some of those questions.
I'm going to ask the next question because it makes me smile. When did David's voice turn into his father's? I can give you a date certain.
You know, I suppose I should say that's high praise.
In my mind, it is.
Because at least that means that I've earned that amount of experience. But to my mind, it also means I'm as worn out as my father, and my father's got a lot of years on him. I got there too fast.
Another remote learning question is remote learning that's required for students in quarantine allowable by take-home materials and electronic communication between teachers and students, or does there need to be real-time remote learning, which not all schools have the ability to do? I mean, I think we're back. It's the same answer as last year in terms of what counts or what's appropriate for remote learning. It needs to be 5 clock hours of instructional activities, and there's a preference for synchronous learning for at least half that time, but it's not a mandate. And I think it's a do your best. I would point out, however, if we're talking about an IEP student, we've got to make sure it's still FAPE, which I think is going to lead us into the next question there. But I think we recognize also that, you know, the comment about not all schools having the ability to do that, I think that part of the intent and a lot of the money that we got was to allow us to provide those services.
Yeah, and one thing that keeps coming up for me again and again this year is now, but we're only required to do blank. And one thing that I'll encourage you all is, one thing I've noticed sort of in subtext of a lot of these cases is that argument, we're only required to do blank, hasn't worked very well with the courts. The courts have really frowned on those arguments. We're only required to do blank has really gotten some districts pummeled by some judges. Now, I'll argue whether the judge is right all day long, but it doesn't do any good if the judge is in charge. So as we're trying to sort of anticipate where we're going, a thing I really encourage school districts to do is to look at that broader, okay, but that's the minimum, but what can we do? And that comes back to who have we worked with? What have we provided? What are we actually able to do? It's a much better argument for me to be able to say, look, I tried my best. I offered this and the parent said no, or I offered this, my union couldn't make it work. what we were able to reach agreement to is this, but take a look at all the proposals from bargaining. We just couldn't do more. It's a function of what we were able to do in the short amount of time we had to deal with it in an emergency crisis. That's a much better argument. So just because we're only required to provide 5 clock hours doesn't mean we only get to provide 5 clock hours. We can do more than 2.5 hours of synchronous instruction if we want, if we can reach agreement as to how we're going to provide that instruction.
Next question is also related to that, specifically, I think, as to special ed students. Are related services required during remote learning, whether that's for quarantine or school exclusion? And I think the answer is it still has to be FAPE. So if we're not providing the services required by a student's IEP during remote learning, then we're going to owe compensatory services to make that up on the back end. So if we aren't providing FAPE, then we're going to have to make that up in some way. If it's not feasible to provide those while a student's on quarantine or excluded from school, then we'll have to figure out how to provide FAPE. But FAPE is still FAPE, and that certainly includes related services and making sure that that does not cause the student to lose those related services. The next question is a huge question. And I think right now we're in a place where the answer to that is a patchwork based on various decisions in various counties that are not all the same as we sit here today. The question here are, what is the recommendations for refusals to comply with the local health department quarantines beyond 48 hours? Now, I think from the school district's perspective, there is an answer to that question, which is the local health department makes the call, right? On a quarantine, the local health department is the one who makes those decisions, not the school. And that even if we look at the communicable diseases code and those regulations, even exclusions there require the recommendation of the local health department. And I will say that not every judge has bought that argument that they apply, that the communicable diseases code provisions that were cited in the ISB resolutions apply. But even if they did, they still only apply when it's upon the recommendation of the local health department. So I think at this point, without a change from the state in some meaningful way, those decisions are made not by the school district, those decisions are made by the local health department.
Yeah. And one thing I want to be really careful of is that we think very carefully about authority. And additionally, as we're thinking about authority, that we're very careful to think about who's implementing that authority. Look, this has been a really fast moving target this year. There's no question the cases are changing the way we view things, and we're having to watch what is a moving target. And so I've encouraged folks that I've talked to slow down as best they can. And to get in really close contact with their health departments and listen. But to that end, it is not a school's duty to enforce health codes. It is the school's duty to work with the health department so that the health department can enforce those codes. Frankly, a lot of us last year, in trying to do the best for kids, got really used to doing things that were outside our authority and outside our expertise. If I were in a room with all of you physically, I'd ask for a show of hands of how many of you became experts in contact tracing. Contact tracing is not a school function, but it's something we all got stuck doing because we were trying to keep kids safe. But the reality is that's a health department function. We're providing them information so that they can do contact tracing. But that's our duty, is to provide them the information that we have that they don't have access to without asking us. But then they do the contact tracing. A lot of us got used to telling our parents when they could not come to school because the parents weren't calling anybody else and nobody else was doing the work. And so you guys bared a heavier burden than you actually had by code. Well, now we're starting to get some folks pushing back on that. And so we've gotten some courts that have said, no, 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 that's not a school district's function. And so I think it's a good opportunity for us to reset ourselves back to where we were as last year started. We feel like we know everything now and it's all changing on us again. I want to reset us back to where we were last year. When last year started, we said, in fact, I think you can find on YouTube one of our old Q&As, and we said it's not a school district's function to quarantine. It's a school district's function to do what the health department directs you to do. And so I want us to reset back there. And the only difference this year is last year, the health department directed it. You said it, and by and large, people complied. This year, they're saying, if the health department isn't telling me, I'm done. So now what I want you to do is to go back to the health department and say, okay, I communicated the message you wanted me to. I'm not enforcing it. You have to enforce it. And that means if you're going to enforce it, send police down here to enforce it. Tell me what I'm supposed to do. I don't want to get into it with my health department, but I'm not going to enforce it if you're not going to enforce it. And what I've gotten a whole bunch of people that I've had from health departments is, well, my health department now says it's my option. Well, if it's my option, the kids are coming to school because I don't have authority to exclude them. Well, we can't get a court order. Well, that's on you. It's not my job to go get your court order for you. And that's really the position that we've been in defending these cases, is that we're sort of stuck arguing to the judge that we've got some authority that we don't, that the court keeps telling us we don't have. Now, I think there was a good argument before 6 months ago that there was that authority. But the ISB change to the ISB resolution doesn't, to my mind, trump what the courts have already said with regard to the code, not the regulation that underlies the code, but the code itself and its authority. And therefore, to my mind, I can't take the position that it is safe to exclude kids without explicit authority.
Yeah, I think a couple things here, in furtherance of those thoughts, David. I mean, one, I don't believe that the ISB updated resolution this week is the silver bullet that I think ISB intended it to be. In fact, I was kind of frustrated because I actually thought their tweets promoting the resolution were clearer than the resolution itself. And if they'd only said what they said in their tweets on the resolution, maybe we're talking about something different. But also, I think it needs to be more than an ISB resolution. I mean, the governor could issue another executive order that would be enforceable. That was clear in that regard. The legislature's in session working on electricity rates this weekend. They could fix this problem in 2 seconds, right? I mean, maybe more like 20 minutes, but still they could do that. And I think that we all
take to write a COVID bill with 3 readings.
Yeah, I mean, I don't mean to be political about this. I mean this to be advice to my, school folks who are listening. Every single one of you should be talking to all the legislators in your region to say, why aren't you helping us out here, right? I just think that right now schools are stuck between the governor and the state and IDPH and ISB telling us one thing. Parents and courts are pushing back on that. And we're stuck right in the middle. And there is one entity that could answer those questions to everyone's satisfaction in an hour's time, and that's the General Assembly. And they're in session this week. And I think that when we all are done today, we should all have, I hope as a lot, as I look at my list here, got, over 100 school superintendents and other school folks, hanging out with us today. And even more of that of other people I see, school board members and teachers and principals beyond that. You all have influence, use it, because that's where I think they need to hear from that. Now, that being said, I want to push back on something a little bit further here, because I think we've got a couple questions about this, which is, but if we let a student back in that we know should be excluded because the health department can't or won't do their part of that, do we have liability concerns for that? Are we making kids less safe if we know a student needs to not be at school under the requirements of ISB and IDPH, but the local health department won't play ball with us? Um, and I think that's where the liability there is potentially on the local health department for making intentional decisions not to follow known and reasonable safety guidelines. And I also think that, you know, our paper trail to them to say, please handle this, is there. Now, I recognize in some counties, it's just a willful refusal by the local health department to meet the requirements. In other counties, it's just a lack of capacity, right? They don't have the time and the staff to be able to do that, especially with case numbers where they're at right now, much higher than we thought they would be. But I just think any decision that we're making in terms of excluding students from school, whether we're using the ISB resolution for that authority, the statute is that authority, the regulations that authority, all of them come back to the same theme, which is the local health department is ultimately the controlling authority there.
Yeah, and I think, I mean, somebody said to me on the phone the other day, but isn't it true that school districts have to make decisions on kids who have the flu every day? School districts have to make decisions on kids who are apparently ill with things that have nothing to do with COVID. And we have to make those decisions every day. And sometimes we send kids home. And I agree that to the extent that parents are compliant, yeah, you got to make decisions on a kid who's got the flu and you send them home. On the other hand, when we have parents who are not compliant, that's where we get into that. I mean, imagine a situation where you've got a kid who's got the flu and you call parents and they don't answer. What do we do in those situations? Do we send them back to class? Of course, we don't send them back to class. We do things to try to keep the kid as much on track as we can while we're trying to deal with the issue. And so, yeah, we're contacting the health department. If the health department says we have no lines in this play, there's a limit to what we can do. There's a practical limit because our authority is really, really limited here. And if the parents send the kid back to school the next day, we're in the same position again. Okay, so the kid still got the flu, but they send him back. Yeah, we've got a duty to keep kids safe. We've got a duty to be reasonable about this. But one of the things that I want to push back on a little bit is when somebody says, well, we got to do the right thing and they should be quarantined. And one thing that I'll say right now is, I don't know what the right thing is. I just want to be really transparent. I don't. Because I've watched everything moving and this is really complicated stuff. And there's a reason that there are lots of these folks coming out. There are all these studies coming out and sometimes they're in conflict with each other in different groups. And we're all trying to talk about what should be going on. And honestly, I don't want to make a judgment call. There's a reason I wasn't elected to anything, folks. I don't want to make a judgment call on what's right on what's wrong, because it's really outside my authority. My job at the end of the day is to represent you in the event of liability. My job at the end of the day is to try to do what I can to try to keep your staff in your school dealing with kids, which is where you belong, not in court with me. And so the best way for me to do that is to talk about where you have authority and then help you manage it day by day in a way that's reasonable given the underlying circumstances. I agree completely with what Brandon said. If the health department is deliberately looking the other way, it's their concern, it's their liability, because we don't have that charge. So if we've got a kid who clearly meets the contact tracing requirements, but is not symptomatic, they're just standing there in your office, and what do? Okay, well, if the health department isn't going to exclude them, I don't have the ability to do so. And so we can argue all day long about what's reasonable, but at the end of the day, I don't have authority. So if I can't get the parents to cooperation to pick them up, then I can't exclude the child at that point, because the health department is looking the other way. And from there, it gets to be reasonability.
And I still just, my gut level frustration of the week is we are being asked from one end to do something, we're being challenged from the other end, and we're the person in the middle who didn't ask for those requirements to be placed upon us.
No.
Right. And so I think it's unfair that we're the ones being asked to defend decisions that we didn't make. That's what I think.
It's so simple to fix. I mean, no kidding. there are not a lot of these situations where I'm like, we could fix this. I know how to fix this. I mean, Brandon, how many conversations we had with various school service organization, legislative representatives, and we've talked through really complicated 15-page bills we're working through. This is not one of those. This is really easy to fix. COVID exception in what I was talking to Luke last night. We were talking about, well, how could this be fixed? And I said, there's this one law that they can literally just strike through the law and that would fix this problem. And he said, yeah, it creates 30 other problems, but there'd be a much easier solution, except COVID-19 during the 21-22 school year. Done. We're done. And then we move forward and it's really clear, but the courts keep coming down on these same rulings because we don't have clear authority. And now we're going to argue and we have these conversations with state agencies and, it's frustrating that we're all in a position where they're telling us from on high, hey, look, this is what the rules are. And I don't mean to be critical of them. I understand how, reading those rules, that makes sense. And frankly, we've tried those arguments. But the problem is when you get in a courtroom with the judge, they're human. And sometimes the judges don't see the scenes the same way we do because Brandon and I and Luke and Jeff and everybody else, we sit from on high too. And we give directives and then you guys fire back at us and the questions and answers and say, let me tell you what's actually happening in my school district. And the judge has a kid who's in that school district, right? And they say, let me tell you what's actually happening to my kid at home right now, what my wife's got to do to stay home so that I can hear this case. There are pragmatic problems here that we're dealing with on the ground. From a legal perspective, there are simple solutions. From a pragmatic perspective of what we've actually got to do when we litigate these cases, they're not simple. And so we need simpler solutions because this is outside what school districts are supposed to be doing. School districts are supposed to be educating kids. I'm done on my soapbox.
Well, I'm going to jump on the next question here because we've got 30 some questions here and I mean, a lot of them are similar questions or the same questions, but let's keep going through the questions here. Would a staff member be considered vaccinated if they provide results of blood work showing that they have antibodies? The answer is no. Our schools now, are schools now required to offer the test to stay program? I think that question comes from one of the various court decisions that required a school to have a testing program, but I don't think testing necessarily means the test to stay program specifically. And I think that in order to do that under the ISB and IDPH guidance, it would require the local health department to also be a party to and approve a test to stay program. So I don't think a school can offer the test to stay program without the approval of their local health department.
And we have some local health departments that have said they won't do that right now because of rates in their counties that they don't believe it's appropriate. Look, I'm not going to argue with you about who's got that authority. What I'm going to say is to the extent that the health department makes that determination, they suffer the foundational liability for it. And also, again, we're not health authorities. So if they're telling us we can't do it, to my mind, we turn to the health department and say, even if a court said, well, you had to do it, let's take that case, Brandon. Even if the court said you had to do it, the court ordered them to get it in place within 10 days. If you had anybody who's been able to get it in place in 10 days, because I haven't. And
no,
so
I mean,
to my mind,
is saying it's 6 to 8,
situation.
it's 6 to 8 weeks away at this point.
Yeah. So to my mind, it's an impossibility situation. So again, I come back to the judge, I come back to the court and I say, I'm doing the best I can. I'm trying to follow your order. Again, that's a very complicated ruling. It's a complicated set of facts. But again, you got to be working with your health department. What is your health department telling you to do?
Is anything required in terms of remote learning for those who are sent home sick that are not a close contact, not COVID positive? For example, they had symptoms, they're sent home, turns out they have strep and they miss a week. Well, I mean, I think if they're being excluded based on symptoms, they might fall within a remote learning situation. So I think if they have the alternate diagnosis, now they're no longer under that framework. And I guess we could cut off remote learning, but why would we? Especially if we're talking about a student who's entitled to FAPE. Remote learning also includes provision of materials to students when they are not present, correct? It can. it's got to be 5 clock hours of materials, you know,
And it's
and of instructional materials of learning, however that looks. I would just caution to say, especially for an IEP student, there are a number of hearing officer decisions around the country that would say just providing, the packets of materials to students isn't FAPE and isn't meeting the obligation to provide instruction under their IEP. So I think for an IEP student, I would pay even closer attention to what I'm providing and making sure that it's FAPE for remote learning.
But given the way the question was phrased there, I want to point out that remote learning requires under 20-30 remote or 10-30 remote learning is the instructional materials and the remote learning instructional materials and instruction. It's not, I don't think it's enough given the way that it's worded to just send work home. I think they're intending more. Now, I acknowledge to you that the code is deliberately vague. It is. I acknowledge to you that maybe that'll meet the standard because it's not clear that it doesn't. But there is, they do have in their guidance there that 2.5 clock hours is what's recommended of live or of synchronous instruction, and that we have to have, I think we have to have something more than just we're sending home learning for the day. I think we've got to do more than that. And again, I think if we're coming to that minimum, we just did the minimum we're required to do. It's at 5 clock hours. I've got 5 clock hours of material because it's what the kids did during the day. It's every worksheet they did. I'm done. I think that starts to look like what we had 2 years ago that ISB specifically said we have to do more this year.
Do we have official guidance about coaches or officials having to be tested? I think coaches is clearly yes, right? I mean, there's no question in my mind that coaches are going to meet that, 15 minutes or more once a week, so coaches, whether they're volunteers or paid, coaches are a yes. I think officials, if they're going to be regularly in contact for 15 minutes or more a week with students, the answer is yes, they need to either submit proof of vaccination or proof of a negative test at least once a week. Now, I got this question today. If I'm in a school doing professional development for a day, more than 15 minutes, do I have to do that? And I said, if you want a copy of my vaccination card, I'll make you a copy. Right here.
That's good. I like that.
Yeah. If you want to apply it to me, I'm more than happy. I'm more than happy. Another special ed question from a special ed cooperative perspective. If a school district offers remote learning through its policy, I'm going to assume that means like a 10-29 remote education program. Under press, that's usually policy 6185. And basically lets anyone who wants to access remote learning do that. And general ed is an online virtual program, that's sort of separate third-party vendor. But what if an IEP student can't participate in that? Can we say the student must be able to participate in a virtual program in order to choose remote learning? I mean, I think ultimately, when we're talking about those 10-29 remote programs for an IEP student, it still has to be FAPE, which means there's still a role for the IEP team in that process. And so ultimately, I think that while that's a voluntary option, the IEP team gets the final say to make sure that whatever is happening is FAPE. So the next 3 or 4 questions are not the same question, but I think they are the same question. So I'm going to read, the next couple questions here, and I think we can just answer them collectively. Where are we at with staff, teachers, or administrators that are refusing to test or vaccinate? Should we honor non-vaccinated employee requests to opt out of testing under the Healthcare Right of Conscience Act if that's cited for the reason for the opt-out? Does the Healthcare Right of Conscience Act apply to exempt an employee from testing? Does the Healthcare Right of Conscience Act grant individuals with the right not to test weekly if they are not vaccinated? Can you discuss the Healthcare Right of Conscience Act? There are lots of here that are the same question. So let's answer that question, which is, let me share how a lawyer's brain works before I answer the question, right? We are trained to look at precedent. How has this been applied in the past to predict how we think it's going to apply in the future? The precedent under the Healthcare Right of Conscience Act all deals really with healthcare facilities and healthcare professionals specifically. So there is no case to go back and point to over time to see how it's been applied in the employment context or related contexts. And I think the other concern here, so then we look at our rules of statutory interpretation and reading the statute based upon how courts have told us we're supposed to interpret statutes, right? There are rules of statutory interpretation set forth by case law that tell us how we're supposed to read and interpret statutes as attorneys. I also know there's an awful lot of non-attorneys who would like to interpret them based upon their own, version of what they read on Facebook. But when we follow those careful rules of statutory interpretation that we as attorneys have to follow, the answer is, who the hell knows, right? I mean, and I know that is not the answer you want. I know you want an answer. You need a specific answer to that question. And I think the issue that we're having is we're also in a situation where there is a no-win situation, right? If we exclude employees and they sue us, that's a fee shifting statute. There are concerns, and there's not precedent to tell us how we think a court might rule on that. On the other hand, we've got an executive order mandate from the state, presumably coming emergency rules, and we're stuck here in between those two. And so ultimately, we're going to have to make decisions based on the best information that we have. And what we've shared, in our newsletter and our conversations we've had with our clients, and I know some of you I've had these same conversations with, is right now we have the ability to wait and see, but that time is ticking away, right? And so we can only wait and see for so long, because at some point we're going to be left with making a decision. And I think that we have to recognize that those are ultimately going to have to be local decisions based on looking at the risk that takes on either one. And I think, again, there's a solution to this problem that either by executive order or by act of the General Assembly, between now and when this testing and vaccination mandate goes into effect, this could be answered, and we don't have to think about it again, because this is a matter of statute, and the legislature could change the statute in an instant, right? They've got, the ability to do that is, if that's what the state is intending, if that's what the governor is intending through his executive order, he has the ability to enact that. And so unless until that happens, we're going to have to make individual decisions for individual employees based on our conversations with them. I don't think it's appropriate for school districts to make broad pronouncements about the applicability of the act. I don't think it's appropriate for them to provide employees with specific forms or advising them as to what their religious objections should or shouldn't be, or putting words in their mouth over what those should or shouldn't be. I think that's very dangerous territory for an employer to be in with an employee. And I think that these are because these deal with closely held individual religious and conscience-based situations, these have to be individual employee decisions made on a case-by-case basis with individual employees.
And I think that the way a school district is going to tackle that is going to be different depending on a lot of factors. So I want to help you with the process. Because obviously we're kind of process folks. That's what we operate from, is a set of rules that create a process. So from a procedural standpoint, we've got until the 19th till the effective date of that order, right? That's till the 19th to collect those vaccination cards. And then we got 7 days after that to implement the testing protocols such that people don't walk in until after those 7 days. So first of all, the crisis doesn't show up until September 29th. That's the first thing that I come to. We're quite a few days away from that process being a crisis. Second thing that I want to point out is that regions have provided a lot of protection here. Even where health departments haven't been helpful, and I acknowledge there have been times the health department hasn't been helpful, the region has, where all the superintendents are talking to each other and they say, one of the first things I'm hearing a lot these days is, well, my neighbors are all doing blank. Early on, I hear, well, I got a neighborhood that's doing this and a neighbor that's doing this and a neighbor that's doing this. But as we get closer to a deadline on thing, well, everybody's doing X. Well, that, I mean, you guys have heard me before. If you're the first gazelle or the last gazelle on the prairie, you're going to get mauled. So staying with the pack is protective. So the first thing I want you to do is talk to your neighbors and figure out how everybody's taking on risk. The second thing is, I don't want broad pronouncements before there are certain rules. I have a real hard time with the idea that everybody can just opt out of testing because it kind of defeats the purpose of the governor's order. And if you take that position and you announce that, I think you're going to have people take you up on it. And I think the result is going to be that the order is ineffective. And by the way, the result also is that the 800-pound gorilla of the governor's office, the IDPH, the ISB, and everywhere else is coming to get you, because every school district, there's always been one in this fight. There's always been the first gazelle out on the prairie, somebody that thumbs their nose at the governor. And when they do, they're the first ones that get mauled. And for anybody who's been in that position, it's no fun. So my advice, and by the way, I had a board along the way here that wanted to be the first and then didn't want to be the first. They went against the order, and then another group of parents, and they made one group of parents happy, and then another group of parents came, and the meetings just kept going back and forth, and it kept getting more and more dangerous. So here's my advice to you. Rather than letting it spin out of control on you, which I think it could, do this. Do less for a little while. I'm feeling very Friday today, Brandon. I am in a do less mood. My advice to you is take in those exemption forms. That don't give them exemption forms. Don't advise them, as Brandon said, don't advise them to try to violate the order. Get those cards in. If somebody didn't get you the card, make sure they're aware of what the order requires. You can bargain it. If the union wants to bargain what this is going to mean, what the rules are, you can sit down and have discussions. Don't be very fast to reach answers. Make sure you understand the issues. Make sure you understand what's coming. Then when we get closer to the deadline, hopefully we're going to have more guidance. But if we don't, then my view in here is going to stay the same, which is that I take in the forms, I'm listening. I'm not quick to take any particular action, because I think the facts on the ground are going to change what it is you do. Look, if you're in a school district where 2/3 of your staff are unvaccinated, nobody's getting vaccinated, and we're having huge outbreaks that are implicating our view of how we keep school open, I'm going to have a different reaction to what risk I'm willing to take with regard to HCRCA than I am if I'm in a little tiny district and 97% of my staff is vaccinated. What risk are you taking on? At some point, there's a reasonability concern. I also think there's a different risk calculus for an enormous district like Chicago Public Schools to take this on. If Chicago wants to take it on, they may set the stage for us. They may get that TRO that tells us what the answer is. Whereas if we have a little tiny school district, if you're in a tiny little school district in Southern Illinois, you've got a grand total of 9 employees. it may not be worth your budget to pay us to go to court on a TRO and charge you $75,000 to get through a process and a preliminary injunction and then court hearings and depositions and notices and all this stuff. It may not be worth going to court for you and then appealing it all the way to the potentially the Illinois Supreme Court, maybe the US Supreme Court on what the HCRCA means. That hasn't been litigated in a school ever. And the last time we had quarantine cases was 1922. We don't know what a lot of this stuff means. And so I'd encourage you to be reasonable as to what's happening in your district, be confident that of what the order says. I'm willing to put the order out there. I'm collecting those vaccination cards. I do think you should do that and keep them separate from your personnel records so that you're protecting them as medical records. And then from there, I think it's a waiting game to see what actually crops up. The answer is going to be different if we've got one person than if we've got an entire school full of people.
Let me shift gears here. Per our CBA, teachers are provided 15 sick days a year. Are there districts through bargaining considering providing additional days due to staff members having to quarantine or providing childcare during quarantine? Well, the FFCRA days, or now I guess the ARP days, the voluntary ability to extend those is only through September 30th. And I don't know very many school districts. There have been a handful, but a very small handful who have extended that at this point. But I think for the most part, it's because everybody thought this was going to be a pretty normal year. We were going to have a bunch of quarantines. And I think that those conversations are coming up. And so I think the question is an important one. And so in terms of our ability to extend further days, like through the FFCRA days, unless Congress were to extend that, those days are done at the end of this month. Beyond that, I think we're at a point where we would have to make individual bargaining decisions about whether or not adding other days are appropriate. Again, at this point, I haven't seen a huge movement or a shift in that direction. I think there are some considerations at TRS about granting additional leave. And so we need to be cautious about the way that's accomplished, how those days are used, what they're called, and other pieces to it. But at this stage, I haven't seen a movement in that direction.
Yeah, one thing I've encouraged people is that I recognize there are a couple of things that we should be aware of. One, the vaccine is widely available. And if we've got the vast majority of our school district has taken us up on the vaccine, they've all gotten the vaccine, why do I need the quarantine leave? Because by and large, those employees or extra sick leave, by and large, those employees are exempt from the quarantine requirements unless they're showing symptoms. The number of times that should be happening should be really low. Hopefully never, but even if it happens, it should be really low. But even if it isn't, union comes back to bargain all the time, right? I mean, if they didn't want to get more every time, they'd agree to a 100-year contract, right? They come back every year, every 3 years, every 4 years, every 5 years. They do that so that they can get a little bit more every time. And how I solve the problem is going to have to be different based on who gets sick. Look, if I've got a bunch of 20-some-odd-year-old women who are all getting sick because they're afraid of the vaccine because of the potential for pregnancy, I'm going to have a different solution than if I've got a bunch of 55-year-old staff members who get sick. Maybe they were vaccinated, but they get sick and they're required to quarantine for periods, but they're near retirement. I have to have a different solution for that. Those solutions are going to be different. And if I try to pull out a crystal ball and figure out what situation might create trouble, what I'm going to end up doing is spending a bunch of money and still having them come back later to deal with the problem that actually happened, because the problem you solved isn't the one that was there. And one thing I can tell you from my own experience, I did this a lot early in my career. I'd hear rumors of bills coming and I'd try to solve them beforehand. And I always ended up creating a bigger problem later. I have one contract that's got a piece of language that was there because I had an administrator who was really worried, and that administrator left that school district 15 years ago. 15 years ago. I remember the conversation I had with him. And at that point, I'm honestly still in my 20s and such a young lawyer that I didn't understand that fear that seemed rational at the time was predicated upon a bill that was never going anywhere. but it had gotten 3 readings. It had been referred to the right committee. I'd talked to a couple of people and they said, oh yeah, that one could really get some traction. And so I thought maybe, but that language is still there and it's costing a district money. And my point to you is, don't assume, fortunately not a lot of money, but don't assume that that language, that thing that might happen is going to happen and that you can solve it now. Go back to your regular rules of bargaining. And remember, we're solving problems that have happened, and we always have the ability to solve them after the fact, and it may be a creative solution.
All right, David, we're going to work through our list here. I'm going to try and do some rapid fire here on some of these questions. When a doctor says the medical contraindication to a mask is autism, how do we handle that? Well, just like anything else, we're going to consider it, just like every other accommodation. I'm probably going to have some more information because there are an awful lot of kids with autism who can wear a mask successfully. So we need to have a little more information as to what's going on so we can make a specific accommodation decision as a team. We had a family who insisted they were going to send their children back to school after 10 days of quarantine because they were not symptomatic. Do we have the authority to deny them coming into school, even though we are adhering to the 14-day quarantine? I think that's a local health department conversation and decision.
Yep, let them make the call.
In the executive order, section 3B seems to conflict with section 3D. Can you speak to this? And then a second question here. So let's do that first. Well, those two sections, 3B is the when people have to get their first dose, and 3D is the testing. I mean, I think that I don't know if they're a conflict. I think they just say two different things, right? I think one says, here's the timeline for people to comply with the vaccine mandate. And anybody who doesn't comply with the vaccine mandate, they've got to follow the testing mandate. So, you know, it almost seems superfluous to have this first dose, second dose language in there because it doesn't really have an effect. Ultimately, if somebody's not fully vaccinated, meaning 14 days after their second shot or 14 days after their one shot, if they do J&J, then they're going to fall within the testing window.
Until they're, so if they've only got the first dose and they're in a 2-dose protocol, they're subject to testing until they complete 14 days after that second dose.
Can we allow subs in the building on September 20th who have received their first dose and plan to receive their second dose within 30 days? I would say if they submit to weekly testing. So by the end of that week would be the deadline for them to be testing. Now, this next question is one I've heard from many people over the last week or so, and it's a real concern here and one that has to be in our factors of consideration. You know, I have several bus drivers that are threatening to resign if they are forced to test. If that happens, we will no longer be able to cover our bus routes. Is there any way around requiring them to test? Well, the way around requiring them to test is for them to be vaccinated. So that's the answer. I'm presuming by the question here, they also don't want to be vaccinated. But at this point, no, there's not. Will there be consequences if we didn't? You know, I think ISB has not formally stated this, but I think my understanding and my belief based on their communication has been that somebody who doesn't enforce the executive order would be subject to recognition status proceedings, just like the mask requirements.
And look, there are a couple of things that I think are going to become clearer as we go here, because I think that if a school district has a board meeting and the board takes the position, we're not going to comply, you're begging ISB to pull your recognition, right? And by the way, that's tough to undo. It's going to take another board meeting. It's going to take action. We're going to have proof to ISB that we have a plan to comply, and we're going to have to prove that we've come into compliance actually with our actions. There is, to my mind, an easier way to deal with this, because if you're not the first cheetah out on the first gazelle out on the prairie, you get to watch whether the cheetah is going after districts, and if they are, how they're handling it. And by the way, if ISB were calling me, one of my first questions is, what meaning this is before the effective date, and they were calling me, one of my first questions would be, so what happens now? What are we going to do?
Yeah.
Because I think that becomes the balance of risks, right? Because again, if I'm going to lose all of my bus drivers and it's actually going to happen, then I need to have a conversation with ISB about, okay, so I have to be able to provide transportation to the kids, and I've literally got 14 resignations in my hand and I only have 28 total drivers. What am I supposed to do? That's a different conversation in my mind than I've got this one guy who refuses to vaccinate or test. And by the way, I hear these threats all the time, and at least last year, and even to some extent this year, they've never been as big as the threat. The threat is like, we're going to have 40 people show up with TROs on the first day, and then it's like, well, 2 kids. It's not that those 2 kids aren't litigation and they're not worth trying to avoid that litigation, but for purposes of avoiding being attacked in litigation, I don't have 40 families I'm fighting against. I got 1, and maybe, just maybe, if I'm quiet about it, meaning I'm not taking them on, maybe I can sort of buy a little bit of time to figure out what the rules are so that I'm not taking, if you take them on here Friday, September 10th, you're doing so 19 days before you actually have to. So why not take a little bit of time, take a big deep breath, and say, I'm going to wait my 3 weeks and just kind of see what happens and see if anybody else gets out on the prairie before I do, so that they get mauled instead of me.
Our local health department is days behind. What's your recommendation when a person tests positive, but the health department isn't going to contact them for a week? Can we send staff home until the health department calls them? I mean, if somebody, the first step is always voluntary compliance, right? So the answer is yeah, send them home. The issue is, at some point, if they aren't voluntarily complying, then we're going to have separate conversations. And, a question here, a couple down, that says, how does that refusal relate to an employee? If they don't voluntarily comply, do we exclude them and have them use sick time? Or, ultimately, I think with an employee, it's slightly different, right? Because a lot of these TROs on students have related to that right to an in-person education. And so I think a paid administrative leave where they're not being required to use leave time, it's not disciplinary, they're not losing any benefits, is probably unlikely to trip the wire of a TRO in saying that they've suffered harm, or the balancing of the harms that, they've suffered irreparable harm that can't be come back when there is, paid administrative leave. And so I do think with an employee, we've got some flexibility, but at the end of the day, it's still a local health department who makes decisions about exclusion and quarantine.
Yeah, and I think we're talking about defense if somebody made that decision. But again, it's the health department's decision. It's not our decision. We can make recommendations. We can get voluntary compliance. If we got somebody, I know this sounds crazy, but we've got somebody who's positive and the health department refuses to quarantine them and they're insistent that they're coming to work, and the health department says we can't quarantine them, they can come to work. We don't have authority there. Now, I do think that we could, say, as Brandon said, I think we could put them on administrative leave because we have more control with employees than we do. There's no fundamental right in the same way there is with kids. On the other hand, be alert to the fact that if you're doing that on a regular basis, you may eventually run into TRS as well, because TRS doesn't just technically their rules permit administrative leave to count for service credit, but that doesn't mean that they're not going to charge you with a sick leave balloon if that person ultimately retires on you. So be alert that there are some complications even with regard to that administrative leave piece.
A couple of questions here about, again, about the exclusion. What do we do with a student standing at the front door and the health department has quarantined them? At that point, that's an action for probably law enforcement to manage for you, because that's who would enforce the quarantine if there isn't a quarantine put out there by the health department.
And if the health department is saying, well, we're not going to do that, and I've had that happen in a couple of places, we call them and we said, okay, so we're going to call the police because you say they're subject to quarantine order. And the health department says, well, no, we're not going to enforce that. And the police say, we're not going to enforce that. Well, guys, it's not your mistake. I understand we're viewing it as maybe a mistake. It might be, but it's not our mistake. We're doing what we're required to do. They're telling us to let them in.
Back to a mask and special ed question. How do you recommend we provide FAPE for an IEP student that is refusing to wear a mask? So I'm going to assume this isn't, we don't have the ability to make an accommodation for a disability here, excluded from in-person instruction, and not eligible for remote learning because they're not being on a health department quarantine or isolation. Well, I think that student falls probably more in the homebound category than anything else. And I think that's the way I would approach providing FAPE to that student. How long can a district ask a student to stay home after showing symptoms? Can we wait until they get COVID results if they tested? Can we require testing? Well, ultimately, I think it's following the decision tree. And as long as the student's complying with that, then we follow that. And so the answers to those questions are slightly different. You know, there is categories, a student who is symptomatic and no testing, symptomatic and tested, and symptomatic and gets an alternate diagnosis, right? And so each of those have slightly different timeframes. And so I think we would look to the decision tree in making that decision. Are there implications with using district staff to coordinate and facilitate shield testing as opposed to using their provided staff? I would say if we are using district staff, you know, there are potentially some bargaining implications of that, especially if we're using staff that are either not school nurses and or not administrators. You know, I think that our ability to assign those tasks under the shield testing or other testing regimens to administrators or school nurses are relatively clear in my mind. The ability to assign them to other employees is going to be, I think, limited and certainly be a bargaining issue.
And there has to be a waiver there has to be a waiver of certain rights, CLIA waiver, for district staff to be able to do that. But that's going to be the responsibility of the provider of the testing for you to seek those. They'll provide you forms and you've got to fill out those forms and then you have to get cleared. And once you do, then you can provide it. But again, just as Brandon said, we can't order certain staff to do it. So the question is going to be, will there be volunteers to do it? And if there are volunteers to do it, what are we doing to keep them safe? And that's a collective bargaining issue. I'm
going to take a question out of order here because I think it just relates back to an answer that we recently, something, you just clarify something you said, David. You know, is the executive order date is September 19th. So do we have to have a negative test by the 19th or sometime during that week? I think our thoughts on that is, again, subject to any further emergency rules or guidance issued on the topic, which could change the answer. But based on reading executive order, that's the first week for weekly testing. So our view on that has been, unless there's a change through, you know, further guidance from the state or through emergency regulations, that the deadline for that first test, that weekly test, is within that first week of September 19th. So the end of that week. So I guess that would be, you said the 29th, but I guess that's really the 24th, right?
Yeah. But I've had a lot of health departments said, I said 29th, I meant 19th to 27th.
Okay.
I know there are a lot of health departments that say that following Monday is the day by which proof has to be received. So again, this would be another place where, to my mind, the health department authority is a big authority on this, that if they're saying we need to have documentation by X date, that Monday, that's when I need to have it. If the health department is saying by Friday, okay, I'm listening to that. But again, it's that first week after the 19th.
What do we do as a district if the local health department asks the school administrators to assist with close contacts and quarantine decisions by excluding students because the local health department is being overwhelmed? One, I would ask the local health department to direct us to do that in writing, right? Because I think even under the communicable diseases code, if that is going to apply, there has to be a recommendation from the local health department to do that. So the first thing I would say is I want a directive in writing. But again, I think even at the end of that process, the health department is the decision maker here and not us.
Yeah, and one of the things that's been frustrating me is health departments doing exactly this kind of stuff where they say, we're overwhelmed, so you do it. Guys, we don't, it's not our job to fund the local health department. I mean, I understand that they're overwhelmed. We are too. You guys have enough on your plates. You don't need to be taking on their work. So my response to the health department is, I'm happy to provide you the information. The information I'm statutorily obligated to provide to you. I'm required by the order very clearly to provide you the information. But I don't do contact tracing. I provide you information. It's your job to do contact tracing. So if you choose not to do it, that's going to be on you. I can't take on responsibility for your statutory obligation any more than I can take on the responsibility to go arrest people for committing crimes out in the community. I understand the kid had a gun when he was at home and playing with his brother. I understand that's a crime. I don't have authority to go out and deal with that. I understand you don't have enough police officers, but that's your job. It's not my job. And if I go into the kid's house and I attempt to arrest him, there's going to be liability for me, because at the end of the day, I don't have that authority. I don't have the exemption you have to make those decisions.
I totally agree, but I do want to go back to a point that I think a couple people made, is the vast majority of parents are compliant, cooperative, and even if they don't like it, hey, when my kid got quarantined, I didn't like it either. It upended my life, right?
Right.
And but I voluntarily complied, right? I didn't make the county go out and get a court order or something like that, right? And that's where the vast majority of parents are going to be. And so again, handling these things individually, quietly, working with parents, recognizing what the limits of our authority are, that doesn't mean we don't try, right? Because voluntary compliance is always step one. And in 99% of situations, we're going to get voluntary compliance. I think what we're talking about here,
yeah, I'm totally good with having conversations with people and trying to get compliance where we can. But look, if you get pushback from folks, I don't want you to forget for a moment. And one thing I worry about where we get outside the boundaries of our authority, when we're doing that, is the health department becomes reliant upon that and believes they don't have to do anything. And Brandon, reading one of those decisions is exactly what I get concerned about, is that the health department effectively ducks out, saying we gave advice, but the school district made the call because that's what they've been doing since the beginning. Look, I'd have advised that it's not one of ours. I would have advised that school district the same way at the outset that whoever advised that school district did. On the other hand, having read the order now, one thing that concerns me is I'm reading that order to say the health department got a pass from the school district and maybe shouldn't have. And so one thing I want to make sure we're doing is not giving the health department the view that they don't have any responsibility here because we'll just do it for them and we'll take all the liability as well. Because I think that's one of the things that's getting us killed.
What happens if we can't comply with the testing mandate, or we can't find test or testing locations for staff? I mean, ultimately, like I said, I think it's going to be if we just refuse to do it, we're going to have a recognition problem as part of that. I think if we're making good faith efforts, that's one thing. But I would say what I think has been communicated very clear. I mean, I got a question here in an email about this, and I've seen this. It seems like IDPH's stance at this point in time is it's up to the employee to go find testing. It's not up to us to provide it to them. And so I think the issue is while we should probably try and make that easy, there are bargaining implications of that. We want to try and do that. Ultimately, at the end of this process, it's up to the employee to go find testing. And get vaccinated or go find testing.
And from the beginning, that I think is part of the purpose of the order, is to make the testing requirement at least a little bit onerous to try to encourage vaccination. I'm not suggesting that we should make it more onerous. We do what we can, but where the individuals refusing, where the health department is unable to help us because they don't have enough tests, at the end of the day, it is the employee's duty to bring us the test.
What approval or documentation is needed from the local health department to use test to stay? I mean, ultimately, I think they need to be written recommendations and directives from the health department.
Yep.
So back to a previous question, if a student sent home with possible COVID symptoms, do we or do we not start remote services before the quarantine order? I say start it.
Start right away.
Do you want to type up and share a list of things we can discuss with our local legislators? Well, sure, but I think it's the thing. It's quarantine and school exclusion authority. It's the application of the Healthcare Right of Conscience Act. I mean, I think those are the two things that are out there. And I think maybe the mask mandate is still getting litigated, so that might be number 3. But I think the two things that the legislature could could take that off our plate instantaneously are school exclusion authority for close contacts and others, and the applicability of the Healthcare Right of Conscience Act.
And here's the thing, I'm not taking a position on whether we ought to be quarantining kids or not quarantining kids. But here's the thing, I don't like getting guidance from ISB. You've got to do this. In IDPH, you should do this. And then courts, you can't do this. Those 3 things are necessarily in conflict, and you guys are caught in the middle of that conflict. I hate that. Let's make the rule clear. Whatever the rule is, you guys tell me what rule you want. I don't care what the rule is. I want the rule to be clear so the school district has a mandate directive. Usually when we're dealing with cases that end up in litigation, there's a very clear rule and the question is factual. Did we violate it? Did we not violate it? That's what I'm looking for here, because now what we're arguing about is there is no clear rule. So what does this particular judge think about what should be the right answer? And guys, I could poll everybody who was on this from start to finish, and my guess is I'm going to get all kinds of different answers as to what right and wrong is. And the problem is any one of you could be our judge, and that puts us in a really tough position.
How is it the school district responsibility to determine if the Healthcare Right of Conscience Act applies to one employee, not another? I would think if it's decided locally to exclude staff from testing who present an argument, would you apply that to every staff member who also presents the HCRCA argument? Well, I mean, ultimately it is our responsibility, right? Because we're the employer. So it falls on us to make that decision. And that's where I think we're not putting the words in the employee's mouth, right? They're telling us what their objection is, and then we're deciding what to do with that on an individual basis. And maybe those decisions are similar for different employees. But, I think just saying, hey, anybody who gives us this, we're going to automatically approve it, is probably not compliant with the order.
And look, I acknowledge that making these decisions on a case-by-case basis, individual basis, is going to be kind of difficult. I also understand and acknowledge that we don't want to be reaching conclusions based on the veracity of somebody's religious claim. That's going to be a difficult thing to litigate, one religious claim versus another. I acknowledge the quagmire that is. I mean, candidly, I think I can make a case out of it in a lot of circumstances, particularly where somebody's been long vaccinated against lots of illnesses. Now, all of a sudden, we're saying no to one vaccination. Look, I can make a case out of it. I don't want you to think I'm ducking the litigation. On the other hand, I do want to be clear that I don't think the answer is bolt clear right now. And so some of this comes down to, because it's unclear, how bad do you want to be the first defendant, and how likely are you to be the first defendant? And if we get real lucky, it won't be anybody who was on this today. It'll be somebody in Chicago, or for that matter, in a county way down south, who gets the opportunity, who isn't one of you. And we can get an answer that then we can take and say, okay, so this is what we know the answer to be. Or if we get even luckier, the legislature, the governor, ISB, IDPH will issue one consistent answer with one consistent rule that we can all follow. I know I'm going to hope in one hand.
I've got some oceanfront property in Arizona to sell you. All right. A couple more questions here before we wrap up. Can we voluntarily offer FFCRA only to those who are vaccinated and test positive, but not offer the same leave for unvaccinated while quarantined? I mean, ultimately, I think there's a bargaining piece to that in terms of what we ultimately agree in terms of the leave that's available. But my only word of caution here is, to the extent we're eligible for any of the tax benefits for that, if we're not doing FFCRA as written in ARPA, then I think there's concern whether we're going to get those tax benefits. But I don't know that school districts are making those decisions based on the availability of those potential back end tax benefits. So I may not call them FFCRA leave at that point.
Yeah, you got a secondary problem there too, and that is you're potentially discriminating on the basis of religious exemption and disability, meaning if somebody can't get the vaccine, you're discriminating against them potentially. You might also have a religious exemption. You got somebody who refuses to be vaccinated for well-established religious belief. There are religions that are exempt from even other vaccines in the state of Illinois. I'd be a little bit concerned that we're potentially discriminating against them. So a discriminatory rule like that does cause me at least a little bit of concern.
So the last question in the queue, and if anybody has any other last minute questions, we got a couple minutes here left, but if we end up on non-compliant probation again, does the 60-day count start again, or do you pick up where you left off? I mean, I don't know that there is an answer to that, other than, I mean, my knee-jerk reaction to that is that's a new probation for a different purpose. As long as you're back to fully recognized, you'd start back on probation again. But I think if you've got a history of probation, that's going to be a factor on all of those decisions.
And there are a couple of red herrings here that concern me a little bit. First of all, remember that ISB's rules are ISB's rules. ISB makes those rules so they can change those rules. Remember that, yes, they have to go before JCAR and there's a process. However, anybody remember timeout and restraint? How fast did that rule come down? When they want an emergency rule, they can pass an emergency rule, which gives them, was it 120 or 150 days?
150 days
of applicability. So they can fix that for you if they want. The second thing that concerns me there is, okay, so we're not in compliance and we go through the process. We don't really know because ISB's never done it before. So I had a lot of school districts say they're going to put us on probation. What does that mean? I don't know. Could bonds be pulled? Bond says you have to be in full, or bond says you have to be in fully recognized status. If we're on probation, are we in full recognition status? Well, that's old arcane language. It's been there forever in your bond. Nobody ever thought about probation. I don't know. Maybe they will call up your bonds because technically when you're on probation, you're not in fully recognized status. And does it say recognized or does it say fully recognized? Does probation include that? We don't know the answers because it's never happened before. We are in a totally new environment. So my caution to you before you take a position is, if you're going to take on a fight because you want the fight, and I recognize there are districts along the way, the boards that have decided they want the fight, don't assume you know the answers to something that's never been litigated simply because the rule looks really clear to you. That's one of the tough things about our job is we read these things all the time. We think Brandon and I think we both think we're really smart sometimes. And then we get in front of a judge. And the reality is that we're only as smart as our ability to read the rules and see them the way we do. But that doesn't mean that the judge in the individual circumstances in which they're living is seeing it the same way. History isn't black and white. The future isn't black and white. It's certainly not black and white. So do me a favor, before you take a hard and fast position, ask yourself whether you need to be the first cheetah or the first gazelle on the prairie, or whether it will be easier for you to wait and see if we learn something. Because I think at this point, we know a lot more than we did 3 months ago about what some of those orders mean.
Question here. We've answered this one already, I think, a couple times, but we'll answer it a third time. I think if somebody has the first dose but not the second dose by September 19th, they test until they are fully vaccinated. Well, friends, thanks for hanging out with us today. I know Brandon, right now
we have the nice even number of 50 questions answered. I love that. That extra
no more
one.
Questions. No more questions. We hit 50. right now is hard, right? We're getting hit from both directions, like I said, and we're trying to please everybody, and everybody is so divided. It's hard to do that, and so I know what you guys are all dealing with on a daily basis. I know the stress you all are feeling, and we feel it for you. And as many of you have heard me say many times, um, I love that I have the opportunity to represent public school districts. I am such a believer in public education, and being sort of an educator adjacent. I'm proud of that, and I think you all need to be proud of what you all are doing on a daily basis. It is hard right now, but kids are in school and we're making things happen, and we're going to get there. But we got to take it one step at a time and one day at a time. Look at the information we have when we have it, and make the best decisions we can based on the information we have, as it comes in and as things change. Because certainly things have been changing pretty quickly. But we've learned to adapt, and we're going to keep adapting, and we're going to keep succeeding, because that's what we do.
Thank you all for all you're doing to keep our kids in school. I speak not just as a school lawyer, but as a parent who spent an awful lot of time with his kids in the last couple of years. I'm grateful for the time I got, but I'm also grateful that they're back in school, because they need to be. I can't tell you how much happier my kids are today now that they're back in school. And I know that all these questions, as much as I'm watching cases come down and I'm trying to advise you guys to try to avoid having to spend a lot of time with me, I'm also trying to understand every day how hard it is to make some of these decisions. I want to say to all of you from the bottom of my heart, thank you for doing what you're doing to try to keep kids where they are in school. Because suffice it to say, there's never been a time in history where it was more important. And you all these questions are coming from a place of love for kids. I hope you never forget that's why you're doing this, and I'll try not to as well. So thanks for that. And thank you, Brandon.
No, absolutely. I echo everything you said. So thanks, everybody. Go enjoy the weekend. We just got a couple nice weeks before it's fall. Let's all have a good time, and try not to read any guidance this weekend, right? Let's do that for you. All right. Thanks, everybody.
Have a good weekend, everyone.